Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about something that frustrates every one of us who geek out on this channel, and it's not the obvious disdain that many of these courts have for your inalienable rights. It's not the obvious disdain that they have for lawful and responsible gun owners nationwide, but rather it's all of the delay tactics, all the gamesmanship, all the shenanigans that these courts go through to keep you disarmed. So we figure we'll probably be talking about the Ninth Circuit today, right? Wrong. No, we're actually going to talk about the Fourth Circuit, because in some ways what they're doing is becoming even more egregious than the Ninth Circuit, if you thought that was even possible. I'll connect the dots for you today. So today, let's spend a few minutes and let's talk about the dirty games the court will play to keep you disarmed. Okay, so what are we talking about today? We're talking about the Fourth Circuit and all the gamesmanship and horseplay that's going on over there to make sure that many of the citizens within the Fourth Circuit remain disarmed. The Fourth Circuit, by the way, comprises Maryland, North Carolina, South Carolina, Virginia, and West Virginia. We're going to be talking about two cases. One we've geeked out a few times before. That's Bianchi v. Brown, formerly known as Bianchi v. Frosch. And then we're also going to talk about a case of the United States v. Price. Now, just to give you guys an overview of what happens when a case typically gets to one of the circuit courts, is if the circuit court accepts review, it will then be argued in front of a three-judge panel. Upon the ruling by that three-judge panel, the losing party would have the right then to ask for review by the entire panel, and each of the circuit courts has different number of judges that comprise a full panel, but it usually ranges somewhere between about 9 and 13 judges, okay? And then obviously if the full panel accepts that, then there can be a reversal of what the three-judge panel previously ruled. And that's exactly what we saw in Miller v. Bonta. That's exactly what we saw in Duncan v. Bonta. Now, the first case we're going to talk about is Bianchi v. Brown. This case was sitting on the doorsteps of the United States Supreme Court in the summer of 2022 when the Bruin decision was handed out. Shortly thereafter, it was GVR'd, review was granted, ruling was vacated, it was remanded down to the lower court for reconsideration, now applying the correct legal standards. That occurred in the summer of 2022. By December of 2022, the parties did argue Bianchi v. Brown in front of a three-judge panel. So at that point, things are moving along by court standards at a pretty decent clip. However, come January of 2024, there hadn't even been a ruling by the three-judge panel. And to this date, there is still not a ruling, nor will there ever be. Why is that? Well, because on January 12th of 2024, the Fourth Circuit just decided to swoop in and take this case en banc without the three-judge panel ever issuing a ruling. And now oral arguments is set for that on March 20th of 2024, which means even if oral arguments occur on that day, you're likely to not have a ruling for an entire another year afterwards, which explains why the Firearms Policy Coalition and all the other plaintiffs in this case has finally decided to say, you know what? To hell with the Fourth Circuit, we need to go all the way to the United States Supreme Court, and they have now applied for certiorari under Supreme Court Rule 11, saying, hey, let's just skip the Fourth Circuit. We can see all the gamesmanship that's going on here. Let's get this thing before the United States Supreme Court right now. Now, that involves an incredibly, never really seen before move where an en banc panel takes a case that a three-judge panel's been sitting on for more than a year and just sucks it up and says, nope, we're going to take this case now, without allowing that three-judge panel even to issue a ruling. And one obviously can probably read between the lines that the full panel did not like where the three-judge panel was going to rule, and therefore they just basically sucked this thing up like a Hoover vacuum cleaner. That is one example of the gamesmanship that the Fourth Circuit is playing. But you see, this is not isolated to Bianchi v. Brown, because there's another case out there called United States v. Price. Now, United States v. Price is a case that challenged the constitutionality of 18 United States Code Section 922K. What is that? That is the federal statute that says you cannot possess a firearm that has a obliterated, altered, removed serial number. The lower court there found that that law did not have any historical analog and has struck it down as unconstitutional. That was appealed to the Fourth Circuit on October 24th of 2022. Okay, so about a month and a half before they heard oral arguments on Bianchi v. Brown, October of 2022. It was, however, not argued in front of a 3-judge panel until December 6th of 2023, 14 months later almost, okay? And despite the fact that it was argued in December of 2023, as of January 12th of 2024, there had not been a ruling from that 3-judge panel. And guess what happened? Oh yeah, that's right. The Fourth Circuit swooped in again and took that case on an en banc review as well. So now we have 2 instances involving Second Amendment cases, significant Second Amendment cases, where the 3-judge panel heard argument, waited forever and a day to issue a ruling, and then had the en banc panel just swoop in and take review of this. Now, I can assure you, if you go back and you scour through all the case law of all the various circuits, we rarely, if ever, see this. We did see in Duncan v. Bonta how the Ninth Circuit decided rather than let this thing be reappealed to the 3rd Circuit, they just sucked it up and took it straight to the en banc panel. But in both of these cases, in the 4th Circuit, the 3-judge panel was presumably within weeks of issuing its actual ruling. Now, this demonstrates, when we take a look at the 4 cases right now that are stacked up before the United States Supreme Court to review assault weapon bans, why the case of Bianchi v. Brown is a case that should absolutely be accepted, and why there probably should be a petition filed on Miller v. Bunta, because some of the gamesmanship that has occurred in the 9th Circuit in Miller and all of the horseplay that's gone on here in the Bianchi case in the 4th Circuit is something that the Supreme Court needs to step in on. There is a lot more at stake on these assault weapon bans. It is not just about your Second Amendment rights. It is not just about applying the common use test to the modern sporting rifle. It is about the entire rule of law and whether or not lower courts are actually going to follow higher courts' precedents. Okay, the cases once again are Bianchi v. Brown and United States v. Price. We will link them up down below so that if you guys want to geek out on all of that, you can do so. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down there in the description box. And then let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.